Hi students! In this video we're going to take a look at a case titled Grutter versus Bollinger. And this is a case between Barbara Grutter and I think it's maybe Lee Bollinger? I'm not sure. He was the president of Michigan, the University of Michigan, when Barbara Grutter applied to be a law student there. And this case is about, as I suggested last time, it's a case about affirmative action. So let's take a look at the facts. So the University of Michigan's law school was one of the best law schools in the nation. It receives, or at the time received, roughly 3,500 applications and admitted 350 students. That is about 10% of the people who applied. So it's hard to get into. When it was selecting those students, and this is a quote from the opinion of Justice O'Connor, who wrote the majority opinion. She said, when it selected the students, the law school seeks a mix of students with varying backgrounds and experiences who will respect and learn from each other. Toward that end, the law school evaluates applicants and their academic abilities, as well as their talents, experiences, and potential to contribute to the learning of those around them. So again, this is another quote from the majority opinion, just saying there's sort of a well-rounded evaluation. We're not just looking at test scores, but we're looking at a variety of factors that contribute, that are going to play a role in how those students contribute to the learning of their law school classmates. More specifically, the University of Michigan evaluates students' GPAs, their LSAT scores, where they study, the difficulty of their courses, the strength of the recommendation letters, and their essays on how they would contribute to the life and diversity of the law school. So they evaluate a variety of different factors. Now, although the law school looks for diversity of all kinds, its admissions policy explicitly states that it's committed to having a racially and ethnically diverse student body that includes students from historically disadvantaged groups, namely African Americans, Hispanics, and Native Americans. The law school also says that it seeks to enroll a critical mass of such students in order to ensure that each student is able to make a unique contribution to the school's character, and we don't get some sort of tokenizing effect here. All right, so that's sort of background about Michigan's admissions process. But what about Barbara Grutter? So she was a white Michigan resident who had a 3.8 GPA and a 161 LSAT score, which is pretty good. It puts her in approximately the 83rd percentile of students taking the LSAT. Initially, she was waitlisted, so the thought was maybe she'll get in if some people end up not attending, but she was later denied admission. And what she alleges is that the law school discriminated against her on the basis of race. She also says that no compelling interest justified the University of Michigan to do so, and therefore the law school violated the 14th Amendment's Equal Protection Clause. All right. So the central legal question in this case, does the University of Michigan Law School's admissions policy violate that Equal Protection Clause? If you don't remember from last time, we can take another look at that Equal Protection Clause, and that says this: no state shall make or enforce any law which shall deny to any person within its jurisdiction the equal protection of the laws. So is the law giving equal protection to Barbara Grutter or not? That's the question we're looking at. All right, so what do you think? Spend a little bit of time before we look at the details of the case to sort of form an opinion of your own. Do you think that admissions policies that are like Michigan's, do they violate that Equal Protection Clause? Now, if you've read it, right, you've already got a sense for how the arguments might go. If you haven't read it, maybe you just have some pretty theoretical opinion, right, or judgment. You know, to expound maybe just a little bit on what the choice you're facing here is like, is it wrong to take race into consideration at all when it comes to deciding who you're going to admit into your university or not? If you think no, like race shouldn't be a factor at all, then you're going to think well, maybe there's a problem with equal protection. People like Barbara Grutter aren't getting that equal protection. If you think, oh, well, you can consider race as long as it's just a mere factor, or like it's being used in a sort of important way, then maybe you think, no, this policy doesn't violate the equal protection clause. Anyway, think about it, form your own opinion, right? And in addition to sort of taking a side, right, think about why you hold that view that you do, and then we'll go from there. All right. So the central question we just looked at, does this law school policy violate the equal protection clause? How did the court rule? What do you think? In this tightly decided case, right, 5-4 opinion, the author is Justice O'Connor again, right? She's important because she's sort of in the middle between the more liberal and the more conservative justices. She rules, and the majority rules, that the law school's race-conscious admissions policy passes strict scrutiny and therefore doesn't violate the equal protection clause. Now you may say, well, what's strict scrutiny, John? I don't understand. We're going to talk about that. Okay. So here's Justice O'Connor's central argument. It appears on page 376. She doesn't put it in premise conclusion form like I have, but I'm just simplifying here, right, so that we can evaluate it later. Premise 1 of her argument says, if a race-conscious admissions policy passes strict scrutiny, and to pass strict scrutiny you need a couple of things. It needs to be narrowly tailored to serve a compelling state interest. So we're going to talk about what those things mean. But if it does those two things, then it doesn't violate the Equal Protection Clause. Premise 2 says that race-conscious admissions policy does pass strict scrutiny. It does pass the sort of narrowly tailored test. It does serve a compelling state interest. And therefore, this admissions policy doesn't violate the Equal Protection Clause of the 14th Amendment. Okay. So as I said, we need to talk about what strict scrutiny means. So strict scrutiny is a judicial test used to compare the significance of some rights violation or apparent rights violation to the significance of the government interest for which that rights violation occurred. So the thought here is like, we're going to give everybody rights, and those rights are going to apply like in almost all the cases, but there might be some cases in which you need to kind of violate someone's rights in order to protect some really important interest. So take, for example, laws that prohibit you from sharing government secrets. Now, if you remember, right, the First Amendment says we have a right to free speech, we have a right to say whatever we want. But the thought is that there are some cases where the government's got this really important interest in something, and so we're going to curtail your right to free speech in order to ensure that the government can accomplish that important goal. We want people to speak freely, but if you're going to be lying about people, well, the state's got some interest in not letting you lie about people, not letting everyone lie about everyone else. So we're gonna eliminate your freedom. You sort of reduce your freedom to do that. So that's the idea here. We've got some general principle, like race shouldn't generally be considered maybe, but if we're going to consider race and use it here, maybe there's a kind of rights violation in the vicinity. Then the government's got to have a really important interest in that, and we've got to sort of look carefully, right? The strict scrutiny is sort of like, we're going to like really scrutinize whether or not this policy is, as we're going to see, in support of a compelling state interest and is narrowly tailored. So to pass this strict scrutiny test, this close investigation, the policy must promote a compelling governmental interest, and 2, it must be narrowly tailored to achieve the interest. So what's a compelling government interest? The thought here is like, we've got to have the government's got to have some interest in achieving some like important goal. If the government wants something that's like not really all that important, then we're not allowed to violate anyone's rights. So if the government would really like everyone to wear pink on a certain day, we're going to say, well, why? You know, does the government really have a compelling interest in having everyone wear pink? And if the government can give us some really good reason, then maybe yeah. But if not, then no. And it's got to be narrowly tailored to achieve the goal. So we want it to sort of be targeted. So let's talk about the narrow tailoring case. So for something like a policy or law, what does it mean for that to be narrowly tailored? A law is narrowly tailored to achieve an interest when it achieves that interest using the least restrictive means. So I think in a way this image is helpful, in another way it's like sort of not helpful and maybe a little confusing. So, one thing that we've already looked at is the Ashcroft versus the Free Speech Coalition case. Right? If you want to reduce virtual child pornography, you can't make a law that's overbroad that like prevents people from, any sorts of things that might seem like they're pornography, right? So we need to have it be a little bit more snug of a fit, so we're not catching too much. The thought is like, in a way, like this suit isn't narrowly tailored. It's too big. It would fit someone that's much larger than this person. Now this guy's suit over here, it is narrowly tailored, right? It fits him perfectly. And so that's the thought with this narrow tailoring. If you've got some really important interest, you've got to make a law that gets directly at that interest without getting anything else in addition. Another sort of analogy that I'm thinking of sort of off the top of my head is something like, say you want to catch a certain kind of fish, like halibut or something, but the nets that you're using are also catching like sea turtles and this other endangered species of fish, and you're just sort of like just driving through the ocean, scooping up everything in your wake and killing it all just so you can get the halibut. The thought is that the net, right, it's catching too much. It's problematic for that reason. So that's the idea behind narrowly tailored. We've got to have a net that's like perfectly designed to catch all and only the fish that we want. All right. So that takes us back to our argument. Right? We're just going to remember what it's saying. The first premise is conditional. It says if an admissions policy is going to pass this test, then it's okay. Premise 2 says the law school's race-conscious admissions policy does pass that test. Conclusion, therefore, it's okay. Why I think that premise 2 is true? So we're going to start with the claim that the law school's policy passes strict scrutiny. And I don't think Sandra Day O'Connor, at least in the part that we read, says too much about why passing this test is enough. I think her thought is like, in the past we've said that in order for a policy of this kind that takes race into account, in order for it to be constitutional, it's got to pass the strict scrutiny test, and if it does, then we're good. So premise 1 is sort of, we got precedent. Why I think that premise 2 is true, why I think that this policy does pass strict scrutiny. So we've got to get a compelling interest, right? So what's the compelling interest? In this case, O'Connor says the state, or the law school in this case, has a compelling interest in having a diverse student body. Now why? Why do you want a diverse student body? What's so good about that? This is a compelling interest because having a diverse student body yields educational benefits. So there are benefits to having a diverse student body. What are those benefits? She gives some examples. We get cross-racial understanding by breaking down stereotypes and enabling students to better understand persons of different races. So we get beyond the stereotypes of people of different races, and we get to know them and what they're actually like. That is a valuable educational goal. You might also think that people of different races are going to have different experiences, and so discussions are going to be livelier, more spirited, more enlightened, and more interesting. So that difference of opinion, something that we are really looking for in this class, right? that's going to be a benefit of having a more diverse student body. And then the third one O'Connor mentions is that it's going to do a better job of preparing students to become professionals in a diverse workforce and society, right? Getting experience working with a diverse group of students, students from minority groups that you might not have experience interacting with before. Getting that experience is going to be important so that when you go in and maybe you're a lawyer for a minority candidate or your minority client, then you don't have a bunch of stereotypes right about what he or she is like. Instead, you sort of can truly appreciate that people from historically disadvantaged groups have diverse personalities and are unique individuals, something along those lines. Now, it's important to note that exactly what the purpose is, right? The law school has an interest in having this diverse student body because there are educational benefits that we get from having the diverse student body. The purpose of this race-conscious admissions policy is explicitly not to remedy past discrimination. So the law school isn't saying, well, you know, these historically disadvantaged groups have gotten a really bad rap in the past. We need to make up for that by letting some of them into the law school. It's not saying that. So, you know, please do not suggest that it is, right? It's important. I think that's a really important distinction for O'Connor, and I think she might say, if that were the goal, if the goal was just to remedy past discrimination, then that's not going to be the right kind of compelling state interest. All right. So the law school's policy, we've got this compelling state interest, O'Connor says, and she also thinks that it's narrowly tailored. Why is it narrowly tailored? This is going to go back a little bit to the case that we looked at in the previous video about the Bakke case. So in this case, the law school's admissions policy is not a quota system, right? The University of Michigan is not saying, here's 20 seats that we're setting aside for minority applicants. Rather, it's saying, we're evaluating everyone together. We don't have some number of students that we're looking to get. Rather, we're just sort of looking for some number, a sufficiently large number of minority students. Additionally, this policy doesn't insulate any applicants from comparison with others, right? So again, we don't have some groups set aside that sort of aren't competing with white applicants. Everyone's competing with each other. Another important thing here is that the policy considers race and ethnicity as a plus factor in the context of individualized consideration of each and every applicant, and it does so in a flexible, non-mechanical way. So here's the thought. Being a racial minority is a plus factor. It counts in your favor, but it's not done so in a mechanical way. So it's not like you get 3 points towards being admitted. I think at the time that this case was being tried, there was another case about the University of Michigan's undergraduate policy, admissions policy, that was on trial. And that policy said, well, being a racial minority gets you plus 6 points or whatever towards being admitted. And once students got above a certain number of points, then they were admitted to the university. Here they're not doing that. They're not saying that being a minority is plus 3 or plus 6 or plus 10 or whatever. They're saying, and it counts positively, but exactly how much is vague, right? They don't have some sense in each case, but they can just consider that as part of the person's overall application. And so it's that sort of flexible, non-mechanical approach that the Supreme Court thinks is good. The more mechanical it is, when race is just 3 points every time, that's going to be problematic. All right. So premise 1 seems like it's established from precedent. These race-conscious policies, laws, need to pass strict scrutiny in order not to violate the Equal Protection Clause. The law school's race-conscious admissions policy does pass strict scrutiny, so it doesn't violate the Equal Protection Clause. Now, which of these premises is most controversial? Which one should we object to? We got a number of dissenting opinions in this case. We're going to look at just one, the one in the reading, Justice Thomas's. And Justice Thomas is going to criticize both premises of this argument. He's going to criticize premise 1, and he's going to criticize premise 2. So we're going to take a look at those objections now. So, as I just said, Justice Thomas presents objections to both premises of Justice O'Connor's opinion. First, we're going to look at his objections to premise 2, the claim that the law school's admission policy passes strict scrutiny. Then we're going to look at his objections to premise 1, claim that if the law school's admissions policy passes strict scrutiny, then it doesn't violate the Equal Protection Clause. All right, so here's the first objection to premise 2. This objection says that there's no evidence that the law school's admissions policy promotes a compelling government interest. Right, so strict scrutiny has two parts: compelling government interest, narrowly tailored. He's going to criticize both. So why think that there's no compelling government interest here? So the law school claims that it has a compelling interest in having a diverse student body. We want a diverse student body. Why? Because that body produces educational benefits. But what Thomas wants to say is that the university hasn't provided any evidence that diverse student bodies have educational benefits. The thought here for Thomas is that there's really just no evidence. Like, maybe let's look at some empirical studies, right? The thought is that shows us that there's an educational benefit. And the University of Michigan just hasn't shown us any of that evidence, right? Thomas points out that Justice O'Connor and the rest of the court is willing to just defer to the University of Michigan and saying, like, you know, we're not experts in education. We trust you. You run a school. We trust your judgment here. But Thomas is saying that's not good enough. We actually need some positive evidence that these diverse student bodies have the educational benefits. You say they do. Second, Thomas wants to say that even if diverse student bodies do have educational benefits, it's likely that there are other ways to get those benefits without using race in admissions. So, you know, what is the benefit you're looking for? Let's see how we can do that, how we can accomplish that without a race-based admissions policy. So one thought, like just diversity of opinions, right? You might say, well, I don't need to necessarily have minority students to have those diverse opinions. I can just select for the opinions themselves. Maybe I have a form that students fill out, and if they have sort of diverse views, then we select them to come. Now, I think this is a pretty good objection in some ways. There's another way in which I think I'm not so sure it's right. So if your goal is to sort of combat stereotypes, then it seems like you do need racial minorities in order to combat the stereotypes. So I think Thomas might be onto something here. I'm not sure that he's got an answer to that kind of argument, but you know, what's the evidence that there's an educational benefit to combating these stereotypes? There is no empirical evidence that University of Michigan has offered. That's Thomas's first objection. Second objection, the law school's admissions policy doesn't seem to be narrowly tailored, right? So no compelling state interest isn't narrowly tailored. Here, Thomas says the law school could produce a student body in other ways, for example, by lowering its admission standard. So rather than having this really high standard, and then, you know, a lot of white students meet it, but fewer minority students meet it, and so we need to give sort of minority students some additional consideration to meet the standard. He says, why don't you just lower the admission standard really low, and then you'll catch all the students, right? Then you definitely have a diverse student body, and you can combat the stereotypes, etc. What Thomas thinks this suggests is that the law school's admissions policy isn't narrowly tailored to produce a diverse student body, period. It's narrowly tailored to produce a diverse student body that has elite status. So an elite diverse student body. Now the problem with this, say that's right, say it's narrowly tailored to have that elite status and be diverse. The problem with this, Thomas thinks, is that the state of Michigan might not even have a compelling interest in having a law school at all, he says, but let alone a law school that has elite status. So, you know, does the University of Michigan, does the state of Michigan have an interest in having a law school at all? Do we need more lawyers? That's a question that's open. Maybe we don't need more lawyers, and so we don't really need our law school. But let's say we do need a law school. Do we need an elite law school? Thomas is saying, why? Explain to me why we need an elite law school here. Okay, now we're going to look at Justice Thomas's objection to premise 1 of Sandra Day O'Connor's argument. So here Thomas says, even if the law school's admissions policy passes strict scrutiny, let's say it does, it still violates the Equal Protection Clause if it harms racial minorities. So the thought is, here we've got to violate some people's rights potentially in order to get this compelling state interest. What's the interest? A diverse student body that has these educational benefits. But Thomas is like, well, the whole purpose of the Equal Protection Clause is to protect racial minorities. So if it turns out that affirmative action harms racial minorities, then that's going to be a problem. We can't, just because it passes strict scrutiny isn't good enough reason to think that it passes this Equal Protection Clause. So again here, his argument's going to appeal to the fact that we've got a lack of evidence. He says there's no evidence that racial minorities who are admitted to law school get better jobs than they would have otherwise. So, again, show me the data, right, that says that there's some benefit that racial minorities get from being admitted to the University of Michigan. Now, arguments like this, arguments from like a lack of evidence, they're not as strong as it would be if Thomas had like some positive evidence, right? He might say, here, this is the data that shows that racial minorities are harmed when they're given affirmative action. That would be a stronger argument. Cases where like we lack evidence, though, it's harder to know exactly what we should do in those cases. Now, here's a quote from Thomas that sort of follows up on this point. He says, nowhere in any of the filings in this court is any evidence that the purported beneficiaries of this racial discrimination prove themselves by performing at or even near the same level as those students who receive no preferences. The silence in this case is deafening to those of us who view higher education's purpose as imparting knowledge and skills to students rather than a communal rubber stamp credentialing process. So the thought here is just that, come on, University of Michigan, we're looking for some evidence that people who receive affirmative action truly benefit from this process. Okay, so that's the first point. The second sort of part of this objection is Thomas thinks there's reason to believe that the law school's admissions policy actually leads white students to resent racial minorities more, right? Someone like Barbara Grutter, right, who thinks, oh, I'm being discriminated against, now I'm bitter towards racial minorities. The thought here is like affirmative action might actually do positively bad things might positively harm racial minorities. It also maybe leads people to question whether successful racial minorities, quote unquote, deserve their accomplishments, right? Like, oh, they've gotten some preferential treatment, and so they don't really deserve getting their law degree from the University of Michigan or something like that. And that would be bad, right, if people thought that. All right. So we've gotten arguments on both sides. We've got Sandra Day O'Connor's argument. We've got Thomas's argument. Again, another chance to sort of reflect on this question that we started out with. Does this admissions policy violate the Equal Protection Clause, or does it not? As a reminder, right, what does the Equal Protection Clause say? No state shall make or enforce any law which shall deny to any person within its jurisdiction the equal protection of the laws. Do white students, are they not getting equal protection of the laws here? Or are they? That's the question. Let me give a few concluding thoughts to sort of maybe challenge you. So what I find in most cases is that my white students especially tend to think like, yeah, affirmative action is bogus. We can't, this can't possibly be just. Of course it violates the Equal Protection Clause. Let me just sort of problematize that view a little bit. I want to challenge you. That's, I guess, another theme from our course, right? I want to challenge you to appreciate the arguments on the other side. So here's a kind of argument that maybe challenges you regardless of which side you're on. Okay, so I suspect, as I say here, that many people think that law school's admissions policy should be invalidated, regardless of whether it passes strict scrutiny. Maybe you think premise 1 is false, because you just think race-conscious admissions policies are inherently unjust. They're unfair, and so that's a problem. The thought here is that the admissions policy is a kind of racism in reverse, right? So in the past, we gave preference to white people, and that was problematic. It was racist. Now we're giving preference to minorities, and that's a problem. It's racist, right, against white people. But I think it's really important. This is crucial, right? If you end up writing a paper about this, especially, right? It's important to note the difference between racist policies and race-conscious policies. What's the difference? Whereas racist policies are grounded in the view that one racial group is superior to another, race-conscious policies aren't necessarily grounded in that view, that one group is superior. So, right, slavery was grounded in this idea that white people are superior to black people, that black people are inferior to white people. And so one thing that makes slavery, one of the many things that makes slavery problematic is the fact that it's grounded in this view of the superiority of one group of people to another. And similarly, Jim Crow laws, segregation, things like that, they're really grounded not in this view that, we should be separate or something. Well, why be separate? Because one group is superior to another. But race-conscious policies like this aren't grounded in that same view, right? There's some benefit that we're giving to racial minorities in this case because we think it's got these educational benefits, and our motivation isn't because we think racial minorities are better than white people. Rather, we just think, well, there's this benefit that having an additional, more of these students in our law school is going to have. Not that it's always better to have racial minorities to white people, no matter what sphere we're in. That's not what they're grounded in. The reason this is important because it raises a question about how we should read or understand the Equal Protection Clause. That is, should we read it as outlawing racist policies, or should we read it as outlawing race-conscious policies? So, is the problem that the Equal Protection Clause is trying to get at, is it trying to root out racism, or is it trying to root out race consciousness? And I think there's an ongoing debate kind of in our society right now that, some people say, we should try and be colorblind. And other people say, no, being colorblind is actually problematic in its own right because it ignores the historical disadvantages that racial minorities face. So to give you, a contemporary example of this, we've got this issue about masks, right? It's an issue that I have mentioned before. It's an issue that I'll probably come back to again, but I think it's this really interesting case, right, where we're sort of trying to sort out right now when can we violate people's liberties? Can we discriminate in any sorts of ways? How do we do that? So when it comes to mask requirements, for example, we don't require, in many cases, really young kids to wear masks. Some places, it's actually positively dangerous for people under 2 to wear masks. It might be dangerous for some people with certain medical conditions to wear masks. And we think that exceptions for those groups of people are fine. There's no problem with that. But Oregon actually passed a law that said, whereas people, generally speaking, have to wear masks, not 2-year-olds, not people with health conditions, right? But the general population has to wear a mask, but racial minorities don't. Now, why would you have a policy like that? And the reason for that policy is that black people especially experience racial profiling, and wearing a mask, right? If you think that black people in general are dangerous, and you might think black people wearing masks are especially dangerous, and so you might target them and try and find them guilty of some crime or think that they're probably doing something wrong, so I'm gonna arrest them or talk to them and try and figure out what it is. So black people wearing masks might be especially victims of targeting. And so what the policy does, the law did, was it said, black people don't have to wear masks because they're more likely to be harmed. If they do wear masks, because they'll be targeted, they'll be victims of profiling. Now, of course, there's a massive backlash to this. So the backlash was, presumably a lot of white people who thought, well, why do I have to wear a mask and black people don't? That's unfair. It violates the Equal Protection Clause, maybe. But I think what the mistake people are making in this case is that, like, nobody gets upset when we allow, some state says, well, children don't have to wear masks up to the age of 12. We don't think like, oh, children, like, they get all the breaks, or people with medical conditions, they get all the breaks. For what happened when they passed this law is, like, white people got incredibly angry, and the thought is, just chill out, right? What you're failing to see is that black people are at a disadvantage given this policy, so you're sort of adding some further burden onto this group of people. So that policy is race conscious, but it seems permissible, right? It seems like it's accounting for the fact that black people experience the world differently than white people. And so that's a race conscious policy, but maybe it's permissible. It's certainly not a racist policy. And you see in the anger and frustration of white people, that there is like a kind of racism going on. They're not willing to let black people have any sort of perceived advantage over them, and so they're going to make a stink when something like this happens. So anyway, the general question, right, is that last question I have there. Should we read the Equal Protection Clause as trying to root out racism, or should we read it as trying to institute a kind of race blindness? That's a deep philosophical question that we're going to be thinking about going forward. All right, that's it for this lecture. Have a good one.